and they change based on the legislative. I think it's the only county in the state that decided to do that years ago. They're not too happy. Do that anymore. It's not a school. They could do it. Take that off tomorrow. Yeah. Yeah. Well, it's
Okay. I'll talk really loud. I promise I can do it. Can everyone hear me okay? Okay. Good morning. I'm Amy Funderburk. I'm the clerk of court for the Supreme Court of North Carolina. First, I'd like to thank you all for coming out to hear arguments before our state Supreme Court. Before we begin, I wanted to explain a little bit about how the court system in North Carolina works. Our state court system is established by the Constitution of North Carolina, and our court system exists to protect the rights of parties and to resolve disputes. Okay. Thank you. Is that better? Okay. And I won't have to yell as loud. Now, courts hear two categories of cases, civil and criminal cases. Criminal cases are instituted when someone is accused of a crime, and prosecutors acting on behalf of the state begin a criminal case when they believe that they can show a particular person committed a particular crime beyond a reasonable doubt. Defense attorneys will then present any evidence they have that casts doubt on the guilt of the defendant. They'll also point out any legal arguments for the defendant and point out any legal errors that they believe the prosecution has made in the case. Under both the United States Constitution and the state constitution, a person accused of a crime generally has a right to trial by jury. Now, juries don't decide what the law is. Instead, they find facts, meaning they consider all the evidence that is presented to them, and then they make a determination as to what they believe actually happened in the case. Criminal trials will end with a jury verdict. Either guilty or not guilty. If the verdict is not guilty, then the defendant is free to go. If the verdict is guilty, then some type of punishment is put into place. And that could be probation, it could be a fine, it could be incarceration. Civil cases, and you're going to see examples of both types of cases today. Civil cases are what most people think of as lawsuits, and they involve one party suing another party. They're usually private parties, but the state can sue or be sued as well. The suing party is called the plaintiff, and the party who gets sued is called the defendant. Now, usually the plaintiff wants money from the defendant, but they can also sue to ask that the defendant be forced to do or not do something, for example, to follow the terms of a contract. Unlike in a criminal case, a losing defendant in a civil case is not subject to being imprisoned. Civil cases will end in a judgment which establishes whether the defendant owes anything to the plaintiff, and if so, what or how much. Now, after a trial is finished, whether that's a civil trial or a criminal trial, the losing party has the right to an appeal. There are two levels of appeal in North Carolina. There's the Court of Appeals and the Supreme Court of North Carolina. Except in certain very serious cases, such as when the trial court imposes the death penalty, the first level of appeal is to the Court of Appeals in North Carolina. And then a defendant only has a right of appeal to the Supreme Court if the Court of Appeals disagrees as to the outcome of a case. At the Court of Appeals, cases are heard by 3-judge panels. And if one of the judges disagrees as to the outcome of the case, then there's a right of appeal to the Supreme Court of North Carolina. Otherwise, the losing party would need to petition or ask the court to take the case, and then this court, the Supreme Court, would have the discretion to take or not take the case. So appellate courts don't hold trials. Instead, they will review what happened in the trial court to see if all proper procedures were followed and to ensure that no legal errors occurred. The lawyers will conduct arguments, which you'll see today, in front of the appellate courts, laying out the issues that the court must decide and describing why they believe their clients should win the case. Appellate courts specialize in determining the questions of law. They generally trust the trial court to have determined what the facts actually are in the case. Today, you're going to have the opportunity to observe an oral argument before our state Supreme Court. Each side has 30 minutes to make their argument to the court, and that 30 minutes can go by very quickly. I think Mr. Euchre, or Ms. Euchre and Mr. Ferguson would agree that time can go very quickly. We normally sit in Raleigh, but in honor of the 200th anniversary of the Supreme Court of North Carolina, we are traveling throughout the state to bring the Supreme Court to you all. I hope you enjoy seeing us here. I hope you come visit us in Raleigh. I will very shortly introduce you to Chief Justice Sherry Beasley. She's the Chief Justice of our Supreme Court of North Carolina, and she's just going to make a few remarks to you all about her road to the Supreme Court of North Carolina. Thank you all for your time, and if you could at this time, silence or turn off your cell phones completely so we don't have any disruptions during court. Chief Justice Sherry Beasley.
Good morning. I am Sherry Beasley, and I'm the Chief Justice of the Supreme Court of North Carolina, and we are truly honored to hold court here in historic Salisbury, Rowan County. Thank you so much for hosting. Everybody has been so wonderfully gracious to us, and we really do appreciate everything that you've done to make our visit a pleasant one. I am the Chief Justice of the Supreme Court of North Carolina, and as Amy explained to you, we have been traveling across the state to commemorate the court's 200th anniversary. So in May, we traveled to Halifax and Pitt and Craven counties, and we had 2 days of court in the old state capitol as well. And then next month in November, we'll travel to Johnston, Guilford, and Orange counties. And so I guess I'm supposed to tell you a little bit about myself. I've been a judge now for 20 years, which is sort of hard for me to believe. I went to law school at the University of Tennessee College of Law in Knoxville. I'm a graduate of Douglas College of Rutgers University from New Jersey. And then I just recently, last year, received my Master's of Laws at Duke University in Judicial Studies. And I serve as Chief Justice now. So my role is I became Chief Justice in March of this year. So it's been 6 months. Before that, I served on the Supreme Court for 7 years. I served on the North Carolina Court of Appeals for 4 years, and I was a district court judge in Cumberland County for 10 years. As a district court judge, I presided in all of our courts, civil, criminal, juvenile, and I was a family court judge as well. As Chief Justice, I have 2 roles. I lead the Supreme Court mostly administratively. We hear the same cases. We have the same opportunities to deliberate over those cases, and we have the same opportunity to vote and to write those opinions. But most of my responsibilities for the Supreme Court are administrative responsibilities. But I also lead the 3rd branch of government. So the Chief Justice is at the same level of government as the governor of the state. And as a part of my responsibilities in leading the whole branch of government, there are 6,500 folks across this state who are elected judges and elected DAs and magistrates and clerks of court and court reporters and a whole host of folks who make up our 102 courthouses across the state of North Carolina. So it is an amazing opportunity really to support those people who are working really hard, making sure that folks like you and those in the communities have access to our courts and have the services that are needed and have the resources that are needed. Most folks, just like the folks here in Rowan County, are doing really, really wonderfully well with much fewer resources than they need. So you all should be very proud of your leadership here. I am super grateful that we have wonderful jurists here in Rowan County, and I'm super proud of the work that they're doing. Chief Judge Brown is the chair of the North Carolina Sentencing Commission, and so I'm really proud that he is offering his leadership in that role as well. So thank you all so very much for being here today. I hope that you will appreciate the arguments that you hear before you. One thing I can tell you is that you surely have fine lawyers who are here today for this argument as well as for the next argument. And again, we really do appreciate your willingness to allow us to hold court here in this historic city and county. Thank you so much.
Thank you, Chief Justice. And thank you all for being with us today. We'll be getting started in just a few minutes. And again, I ask if you have your cell phone with you, either turn that completely off or put it on completely silent. When we do finish this session today, we're going to have a session at 11 o'clock after our break. So we're going to need to completely empty the courtroom and fill it back up again. So I'm going to ask if you could, when I gavel us back out, just exit through these doors, I believe is your preference. And then we will start, once we have you all exit, we'll have our next group come in. Thank you again so much for being here. Looking forward to this session. and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning again. We now call the case of State versus Royster. Ms. Euchre.
Good morning, Your Honors. May it please the Court, my name is Kristen Euchre. I'm an Assistant Attorney General with the Department of Justice, and I represent the state in this matter. I'd like to reserve 5 minutes for my rebuttal. Circumstantial evidence is sufficient to send a case to the jury. The Court of Appeals majority erred by holding otherwise. At about 7 p.m. on December 28, 2013, Humberto Anzaldo was in the Otter Creek Mobile Home Park in Green Level in Alamance County. He was visiting friends when he overheard his acquaintance, Polo, arguing with another man named Scrappy. Polo was screaming and arguing with Scrappy about how Scrappy had lost $160,000 worth of cocaine. Polo was there to straighten that out. Shortly after this argument, Polo, Scrappy, and Hector Lopez left the trailer park in a gray two-door BMW. They went to Mr. Ronald Royster's apartment. Mr. Royster recognized one of the men and let them into his apartment. The man asked Ronald if he had talked to his son, Rontel Royster, the defendant in this case. One of the men also asked if he could use Mr. Royster's restroom. When he came out of the restroom, the man said, "Well, if you haven't talked to your son, come on with us." He put a gun to Mr. Royster's head and tied his hands with a cord. The men walked Ronald to a gray two-door BMW where they blindfolded him. They drove around for a while and eventually took him to a building where he was sat on a sofa, and they tied his feet now too. At some point, the kidnappers put a phone up to Ronald's ear and defendant was on the line. Ronald told defendant that he needed to come and talk to the men because he did not know what was going on and he had nothing to do with this. The next morning, the morning of December 29th at about 8 or 9 a.m., Mr. Anzaldo returned to Otter Creek Mobile Home Park. He ran into Polo there, and the two went into a mobile home. Anzaldo saw Ronald tied up and sitting on the couch. Anzaldo said, "You can't be doing this. This isn't Mexico." And he left the home. He and Polo stood outside talking for a few minutes before defendant drove up in an Acura with his passenger, DeMarcus Cates. Polo, Anzaldo, and Hector Lopez went to talk to defendant and Cates. At the same time, Ronald, now untied and unblindfolded, could see he was inside a mobile home. Scrappy walked Ronald out of the mobile home, and Ronald saw defendant standing outside the car with DeMarcus Cates. Defendant told Ronald to get in the car, and so he did. At that point, defendant handed a pretty heavy black lockbox to Cates, who in turn handed it to Polo. The box was then passed to Scrappy, to Anzaldo, and back to Scrappy. At this point, Cates and Polo began arguing, yelling, and pushing each other. 4 or 5 gunshots rang out, and everyone scattered. Anzaldo ran into one of the mobile homes. Scrappy, carrying the black lockbox, ran into the woods. Defendant drove off with his father and Cates. Polo, shot 4 times, was left dead on the ground. Law enforcement responded shortly thereafter to collect evidence related to the shooting. The next day, approximately 18 hours after the shooting, officers returned to do a grid search of the woods with canine officers. They found the black lockbox about 50 to 75 yards inside the woods behind a tree. It contained 1,814 grams of cocaine in several packages. This amount of uncut cocaine had a street value of between $49,000 and $63,000. From this evidence and common sense, one can infer several things. First, that defendant and Polo's group were having a dispute over a large quantity of cocaine. Polo's group kidnapped defendant's father to straighten out the dispute. Defendant then shows up with the closed box that he hands over to Polo as ransom for the return of his father. The box was later found in the woods with a quantity of cocaine worth about the amount of the cocaine that started the dispute. It's also common sense that people do not store large quantities of cocaine in the woods, not generally at least. Special circumstances like fleeing for one's life or from the scene of a shooting where police would be responding imminently might be a reason to do that. Scrappy hid the box and all of its contents in the woods. It's unreasonable to think that someone will come upon the box in the woods, remove its original contents, and replace them with at least $63,000 worth of cocaine. Therefore, it's reasonable to infer that the box contained the cocaine at the time when defendant passed the box to Cates to give to Polo.
Just to make sure I understand your argument, the point at which you contend the court's analysis ought to focus, i.e. the point at which the defendant possessed the cocaine in the state's view, was when the defendant had the box and handed it to somebody?
Yes, Your Honor.
That's the point. So the question is, at that point, was there sufficient grounds to believe that cocaine would be in the box?
Yes, Your Honor. I guess to be a little bit more precise, the point is not whether at that moment there was sufficient evidence, but whether there was sufficient evidence that at that moment Mr. Royster...
The moment that we need to focus on is the point at which the defendant had the box on the day before, had a box on the day before it was discovered.
Yes, Your Honor.
And not the point at which it was found in the woods.
That's correct, Your Honor. At that point, defendant had handed it off to another individual, to Mr. Cates, to do with, as they had agreed, who then handed it to the kidnappers. So he no longer had any ability to control the item at that point.
And the evidence that there was cocaine in the box at that critical point was that they were arguing about that?
That they were arguing about it, and that they kidnapped the defendant's father in order to resolve the argument. And they were arguing about a specific quantity of cocaine worth $150,000.
And so the state's position is that it's proper to infer from that argument that there was, in fact, cocaine in the box?
Not merely from the argument, Your Honor. From the argument, from the fact that defendant's father was kidnapped, from the fact that defendant showed up with the box to exchange in return for the return of his father, that the cocaine was found in the box later, that it's unlikely that anyone would have gone out there and stashed the cocaine in the box later. Those are all of the circumstances.
But there wasn't evidence, as I understand it, that at that moment anyone opened the box and gave testimony about what was in it at that point.
That's correct, Your Honor. There was no direct evidence that anyone opened up the box and examined its contents and could tell anyone what was in it at that time.
What would your response then be to the Court of Appeals' position that any of this then would be mere speculation because of the fact that there was nothing said about the contents of the box, let alone that it rose to a level of being a trafficking amount?
Your Honor, I think, number one, when people have interactions, they don't always narrate what's happening. Sometimes things have to be inferred from the circumstances of the interaction. So you have defendant on the phone call with the kidnappers. Defendant's father tells us that the defendant is the person who can resolve this dispute. Defendant shows up, hands the box over to the kidnappers, but only after his father has been returned to him. It's clear that the box was the ransom for the father's return. And the thing they were arguing about was a large amount of cocaine. And then cocaine is found in the box shortly thereafter.
Shortly thereafter is in the next day.
Yes, Your Honor. Yes.
But just to be clear, the testimony about the argument the day before was that it was about $150,000, but the witness didn't actually say it was $150,000 worth of cocaine.
Sorry.
Is there somewhere else, am I missing somewhere in the transcript where there's specific reference to cocaine?
Yes, Your Honor. I do believe that on transcript pages 641 through 42, Anzaldo testified that Scrappy had, quote, lost $160,000 in cocaine to some black guys from Durham, and so he, Polo, was there to straighten that out. That was the testimony.
Thank you.
The evidence is to be viewed in the light most favorable to the state, giving the state the benefit of every reasonable inference. This is boilerplate language that is cited in practically every case that is argued on sufficiency of the evidence. It's not a radical proposition. The trial court must resolve any contradictions in the evidence in the state's favor, and the trial court is not to weigh the evidence, consider evidence unfavorable to the state, or determine any witness's credibility. Additionally, circumstantial evidence alone is sufficient, even if it doesn't rule out every hypothesis of innocence.
I mean, I don't think there's any question, but that the court has held a number of times that the mere fact that evidence may be circumstantial doesn't determine the outcome one way or another. The real issue in this case is whether a reasonable inference of guilt can be drawn from the factors that you've outlined, right?
Yes, Your Honor.
And so what would basically, I mean, my read of your argument is, one, that the boxes were the same when, I mean, in actuality, there's no direct evidence that the box is the same, right?
No, Your Honor.
I mean, there's a physical resemblance between the two boxes. It was in the same basic area, but the inference that the boxes are the same is an inference. It's not, there's no direct evidence to that effect.
Mr. Anzaldo testified that when the ADA handed him the box and said, "Have you seen this box before?" he said, "Yes, it was the box that was handed to me."
But basically, we've got similar boxes. We've got a dispute between the people that looks like a ransom transaction, and we've got somebody taking a box that the defendant obviously had in his possession at one point and running into the woods, and 18 hours later, a similar box containing cocaine is found in the woods. That's essentially what we've got, isn't it? Plus the statement about there was an argument over something that was valued at $160,000. Is there anything else?
Your Honor, Mr. Anzaldo said that the box was the same. He said, "I've seen this box before. This was the box." That's on page 472 of the transcript. The ADA said, "Have you seen this box before?" He said, "Yes. It's the box from the day of the shooting." Whether this court believes he can know that is a different question. That requires assessing his credibility, and that's something that the appellate court...
But I guess my only point is, or at least point or question is, in fact, you have to make an inference that the two boxes are the same. There's no direct evidence to that effect.
No, Your Honor.
Okay.
That's not...
I'm not misreading the record when I say that.
I don't think that you do have to make an inference that the boxes are the same, because Mr. Anzaldo said they were the same. Whether that testimony is sufficient to convince a finder of fact that they are in fact the same is a different question.
But really, the issue really is, given the state is asking us to infer that the cocaine that the defendant is charged with possessing was in the box at the time that it was handed from the defendant to these other folks, based on the factors that I mentioned. That's the basis for the inference that you're asking the court to draw.
Yes, Your Honor.
Okay. Am I missing anything?
Other than the fact that the state is entitled to all reasonable inferences. It doesn't say one reasonable inference. I don't think that the number of inferences is in any way dispositive of whether the evidence is sufficient.
So to go back to that upon which you want us to focus, all of this that was introduced at trial about the fact that the box was dry, although the surroundings were wet. There was a mason jar that had additional cocaine that was near the black box. All of that, the state would contend, is irrelevant to the issue that you want this court to address, which is the circumstantial evidence being sufficient at the time that the defendant physically possessed the box as it was being handed from person to person the day before.
Yes and no, Your Honor. I don't think I would entirely say that it's irrelevant. I would say that it's not to be considered in the analysis, and even if we were to consider it in the analysis, I don't think that that evidence is sufficient to show what defendant argues it shows. But first, I did just want to correct for the court. I did make an error in my brief. I mentioned that it was defendant's evidence, but there were several witnesses who did say that the box was dry. So I wanted to apologize for that oversight and just clear that up, that is not defendant's evidence.
You're couching your words carefully when you say you would not say that it was irrelevant. To what extent, then, would it be relevant as bears upon your position that it is not to be considered by this court as to being sufficient enough evidence?
To the extent that it is unfavorable to the inferences that the state is asking the court to draw, it should not be considered under all of this court's case law saying that unfavorable evidence is not to be considered in the sufficiency analysis, unfavorable to the state's case.
Wasn't there some evidence that the weight of the box was the same from the time of the ransom to the time that it was discovered in the woods?
Yes, Your Honor. There is. Mr. Ansaldo testified that, again, when the DA in the courtroom handed him the box, which had all the items in it that the officers found in the box, when the DA handed that box to him, he said, "Does this feel about the same weight?" And Mr. Ansaldo said, "Yes, it feels about the same weight," and that it was pretty heavy at the time that it was handed to him. And that those packages of drugs weighed about 1,800 grams when the officers found them and took them out and weighed them.
So it seems like the overall theme is that defendant had the drugs, whether on consignment or not. He was supposed to be paying for them. He had failed to do so. They kidnapped the daddy, and his option was to return the drugs.
Yes, Your Honor.
There's no testimony evidence with regard to the source of the, quote, lockbox. Or, we don't know if that was the box that it was originally in and given to the defendant in the first place, and so he's just giving it back, and so they see the box and they feel the weight and they go, yeah, this must be it, kind of thing.
That's correct. There's no testimony about where the box itself came from. The only testimony about it we have is from Mr. Ansaldo, who saw it that day be brought out of defendant's car by defendant. So that's all that we know about where it came from, is that it came from defendant's car.
The fact that the kidnappers didn't look inside the box, should there be any inferences from that? Should we infer that they thought it looked familiar? Or why would they go to the trouble, kidnap, receive a box, and then not look inside of it?
Yes, Your Honor, that could be an inference that could be drawn. Also, we don't know the content of their conversation. So we're not, maybe they discussed, maybe they directed defendant to put it in a box and bring it, and we also don't know, perhaps, exactly how long all of this took. So perhaps there wasn't time for someone to check it.
But when you use words like maybe this happened and perhaps this happened, isn't that the kind of speculation the Court of Appeals is talking about?
Your Honor, speculation is not based on evidence. It's a guess. Your Honor is correct, there is some overlap there, and it's difficult to draw a hard and fast line between the two. But the state's position is that there is each one of these circumstantial pieces of evidence build to this conclusion that defendant had agreed to bring the cocaine to this trailer park in order to get his father returned. And to go back to Your Honor's question about the relevance of whether the box is dry or not, I think that that's the extent of the evidence, is that the box was dry. That's what we heard from several witnesses. The box was dry. That was it. We didn't hear anything about the exact location in the woods, other than that it was behind a tree. We don't know if something was covering it in some way, and by definition, the woods there are trees and there's a canopy, and we don't know anything about how much it rained, if the rain was able to penetrate the canopy. So merely on its own, the testimony that the box is dry doesn't do all of the work that defendant wants the court to believe that it does. It doesn't show that it was just recently placed there.
Counsel, just to go back, and I'm sorry, but it does seem to me to matter whether the original argument that was overheard was about $150,000 or $150,000 worth of cocaine. And I believe I'm right that the passage you cite at transcript page 641 to 642 is actually counsel's closing argument, and that the relevant witnesses' testimony, this is Anzaldo, that's comes much earlier in the transcript, and that in his actual testimony, the argument was about $150,000.
I don't have those pages of the transcript in front of me, Your Honor. All I have is my brief. I'm sorry. I take your word for it that seems entirely possible, and I apologize for that. This court recently reaffirmed the principles by which appellate courts are to consider whether the evidence is sufficient in the case of N. Ray TTE, where the court pointed out that the Court of Appeals had erroneously decided to ultimately determine whether the juvenile had committed that offense, and that while innocent inferences could be drawn from the evidence, any contradictions or conflicts in the evidence are resolved in favor of the state on a motion to dismiss for insufficiency of the evidence. The opinion said any contradictions, with emphasis on the word any. That also goes to Your Honor's question, Justice Morgan, about the dryness of the box. That to the extent that is unfavorable to the state, it should not be considered. I do want to touch briefly on State v. Butler, which was another case in which this court considered circumstantial evidence and its sufficiency to show possession of drugs. So in Butler, the officers found cocaine under a taxi cab driver's seat about 10 minutes after the defendant had gotten out of that cab. And this court held that the evidence in that case was sufficient to send to the jury. This was based on basically circumstances amounting to the fact that the defendant appeared nervous upon seeing the officers, and then that the taxi cab driver testified that he was wrestling around in the back seat and eventually got out of the car, and the taxi picked up another passenger who also sat in the back seat, and then came back to the location where the police officers ended up searching the car and found the cocaine. That had been about 10 minutes later, and we know that somebody else had access to that location. And this court said that even despite that, the evidence was sufficient to send the case to the jury, that those inferences, those competing inferences, were things that the defendant could argue to the jury, but not, they did not make the state's case insufficient as a matter of law. And the state argues that that is remarkably similar to the case here, although, of course, the time period is not the same, 10 minutes versus 18 hours. But that alone should not be dispositive of whether the evidence is sufficient. Getting just briefly to the waiver argument. Defendant did not make a general motion to dismiss in this case. Defendant's motion to dismiss, based on the insufficiency of the evidence, was on the insufficiency of only one element. He said, as to the charge of trafficking in cocaine, the defendant would move at the end of the state's evidence, dismiss that charge. Period. End of the statement. Then he goes on to summarize the evidence, the gaps in the evidence that he perceived, and then he said, there's absolutely no evidence at this point that this defendant was aware in any fashion of the contents of the box. Everything that he says goes to that point. He never says, makes a motion to dismiss based on the insufficiency of the evidence. He merely says the evidence is insufficient to show that defendant knew that the cocaine was in the box. And that's true.
Just a reminder, you're into your rebuttal time.
Thank you, Your Honor. I think I will go ahead and reserve the rest for rebuttal. Thank you.
May it please the court, I'm Jay Ferguson, and with me is James Williams, and it is our sincere privilege and pleasure today to be representing Rontel Royster before this court and in this county. I told Mr. Williams it's the first time I ever looked down at the court, literally. The first issue I'd like to address is the waiver.
Well, Mr. Ferguson.
I'm sorry?
I said, we can see you really well.
Thank you. The first issue I want to address is the waiver issue. The state argued in its brief, and the dissent below found that the defendant had failed to properly preserve the sufficiency of the evidence issue at trial. And specifically in the brief, the state says defendant did not argue there was insufficient evidence to show that he possessed cocaine. That's their argument. But I want to note that Judge Hardin, James Hardin, was a trial judge, and he instructed the jury precisely in accordance with the pattern jury instructions when he instructed on the single element of possession that's required under the law. It says, for you to find the defendant guilty of this offense, the state of North Carolina must prove beyond a reasonable doubt that the defendant knowingly possessed cocaine. A person possesses cocaine when the person is aware of its presence and has, either by himself or together with others, both the power and intent to control the disposition or use of that evidence. So that's the single element that the state must prove. And the defense attorney, Octavius White, who's a very experienced attorney along with George Hunt, one's the former elected district attorney, one's the former assistant district attorney of Alamance County, seasoned trial lawyers, said specifically at page 650, line 24, this is at the end of the close of all the evidence. Mr. White said, there is not sufficient evidence, not substantial evidence at this point at the close of all the evidence that our client had any knowledge of what was in that box. Then he goes on. Not only knowledge on his part, but there is no evidence at all as to what was in the box on the 29th. None. I respectfully contend that the state and the dissent below simply missed that passage because clearly Mr. White is arguing that the defendant didn't know what was in the box, no one knew what was in the box, and there was no evidence of what was in the box. Certainly that's enough of an objection under Rule 10A3 of the Rules of Appellate Procedure.
What's your response to the state's position that in terms of on one level talking about your client not having knowledge, and on another level saying that there was not possession, that was swapping horses between the trial level and the appellate level, and as a result, there is no basis upon which you can argue the way that you're arguing here in the Supreme Court.
Well, that's exactly what Mr. White argued below. He said, one, the defendant did not know what was in the box, and, quote, there is no evidence at all as to what was in the box on the 29th, none. So that was argued to the court below. So I'm not sure what else a defense attorney could say if the defense attorney is saying the state has failed to present any evidence of what was in the box on the 29th. That is, what the state is doing is cracking open this singular element of possession into knowledge and possession and of knowledge of what was in the box. It's really one element, and that's the element that Judge Hardin read to the jury in the charge conference.
So you're saying there's no line of demarcation between knowledge and possession, that the defendant is being consistent in the positions taken at trial level and the appellate level here?
He's riding the same horse that he rode at trial in the Court of Appeals, and we're still on the same horse. It's that there was no evidence of what was in that box at the time of on December 29th, 2013, and the defendant did not know what was in that box. So there is no. They have argued that, but I want to, and the reason we require specific objections in other contexts is so that the trial judge knows what the trial judge is ruling on. There's no question that Judge Hardin knew. On page 652, line 20, he said, the court, having considered all the evidence, the arguments of counsel, the defendant having made a motion to dismiss at the close of all the evidence based upon insufficiency of the evidence, the court, having considered all of those things in its discretion, does deny the defendant's motion. So the trial judge knew exactly what the motion was and what he was ruling on. But I want to address that even if the state's argument is correct, that there has to be a specific objection, I want to impress upon this court that that would be an absolute sea change in the case law from this jurisdiction. The only case that the state has cited from this court that would be even arguably require a specific objection at the end of the close of all the evidence is State versus Benson. It's a 1951 case. It was not mentioned in the state's brief, but rather in the Memorandum of Additional Authority. And in that case, it does say, it arguably stands for the proposition that a general demurrer to the evidence was insufficient to challenge a specific offense. Now remember, in this case, Mr. Royster's counsel specifically objected to this specific offense. Since State versus Benson, no appellate case has cited State versus Benson for that proposition since 1951. No case has ever held that way since that time. State versus Benson was decided before the adoption of the Rules of Appellate Procedure, and specifically Rule 10 of the Rules of Appellate Procedure. It was adopted prior to the adoption by the legislature of 15A 1227, which is contrary to State versus Benson. So, other than Benson, and I have filed with the court a memorandum of additional authority with, I don't know, maybe a dozen cases from this court which has held just the opposite of that, and that is a general motion to dismiss at the end of the close of all the evidence is sufficient to preserve a challenge to, quote, each essential element of the offense charged. State versus Powell, a 1980 case, is really the case that has held, that is cited probably the most by the appellate courts for that proposition. So to reiterate, if the court were to adopt the state's waiver standard, that would be a brand new rule of law. It would require this court to overturn a generation of case law before it. And I suggest humbly to the court that if the court wanted to impose new restrictions on these seasoned trial counsel that have always simply made a motion to dismiss, that the better course of action would be to amend the Rules of Appellate Procedure. because all of the trial counsel are following State versus Powell and its progeny and making general motions to dismiss to preserve each element of each charge. Now, moving to issue 2, the sufficiency of the evidence. I'd like to start just by answering a few questions that the justices had. Justice Earls, you asked about whether there was testimony about whether the argument was over cocaine or money, and I would respectfully ask you to look at page 452 of the transcript, line 4, question, okay, and he was yelling at Scrappy. This is the testimony of Mr. Anzaldo, I'm sorry. And he was yelling at Scrappy, also known as Luis? Answer, yeah. Question, did he say how much money? Answer, he didn't. I just heard that they said something about $150,000. Answer, a question, okay. Did this argument continue in front of you? Answer, no, they had gone inside. There was no mention of cocaine at that time. It was only an argument about money. And whether...
So are you asking us then to infer that the folks believe that there was money in the box?
There is no testimony, no evidence whatsoever from any witness as to what was in the box on December 29th, 2013. None. Nobody testified what was in the box. So we don't know what was in the box. And any quote, inference would be mere speculation and conjecture. There's no testimony from anyone.
So your position would be, we know that they kidnapped the daddy. We know that they demanded something in return for the daddy. And when they received the box, apparently that was adequate for the return for the daddy because the daddy was released. And so what's in the box?
Well, we don't know if it was adequate because an argument ensued and someone got killed. So to assume that it was adequate is another assumption. We don't know. There is no testimony from Scrappy. Polo's dead. And Mr. Anzaldo says he does not know what was in the box and never looked in the box.
But the daddy's in the car.
Daddy's in the car, that's correct. Daddy was released, that's true. There was a question, and I believe it was Justice Newby, but I'm not sure, about whether this was I believe it was Justice Irvin, about whether this was the same box. And the testimony is found on page 472. Again, Mr. Anzaldo, who was the state's star witness, who said, question about Exhibit 7A, which was the box. And where have you seen it before? Answer, I seen it that day when they approached. Question, you saw a box like this one? Answer, yes. And that was the testimony. So the testimony was it was a box like that one, not the exact same box. I don't disagree. Obviously, circumstantial evidence can be sufficient to survive a state's motion to dismiss. I don't dispute that. I do take issue with one thing the state argued, and that is the state is with Justice Morgan's assertion that the court cannot consider the fact that the box was dry. I do believe the case law is clear that the court can consider all the evidence so long as it does not contradict the state's evidence. The state's evidence, the state's own evidence, was that the box was dry and it had rained the night before. And furthermore, talking about guessing, there was an inference, if you want to call it that maybe the box was covered or the tree's canopy protected it from rain. Now, this was December 29th. No leaves on the trees. We don't know what kind of trees. And also, we know the box was not covered because there was testimony, and I can't cite it to you right now, but there was testimony that they could not obtain fingerprints from the box because the drug-sniffing dog, when the dog went up to the box, it sniffed all over it, and therefore they could not get fingerprints. If it had been covered, they could have obtained fingerprints from the box. So there is no evidence that the box was covered in any way, shape, form, or fashion. We know that the only thing we know about that box on December 29th is that it went from the defendant to Mr. Cates, to Polo, to Scrappy, to Mr. Anzaldo, back to Scrappy, and Scrappy ran into the woods. The assertion by the state that Scrappy's the one that left it in the woods is a guess.
We do know, and I think, don't we, that at least somebody described the box as heavy at the time of the transfer?
Pretty heavy, yes.
So what do we make of that?
Well, I think if I'm not a drug dealer, but I think if I was going to try to fool someone to get my dad back, I would try to make the box weigh about whatever it is that you're supposed to be returning, whether it's paper, rocks, money, monopoly money, whatever's in that box. I wouldn't return an empty box if I'm trying to get my dad back. But there again, we can guess all day long. There is no inference.
I mean, ultimately, at least my understanding of my conversation with Ms. Bucher was that the state is, and I did forget the weight of the box when I rattled off the factors, but it seemed to me the state was arguing essentially that you could infer that the cocaine found on the next day was in the box because the box was of similar appearance. It was in the area into which Scrappy ran. Nobody looked inside the box, and that there obviously was a ransom transaction going on. You've described that as speculative. They say it's a reasonable inference based on the factors that I mentioned. Why should we accept your speculation argument rather than their reasonable inference argument? I mean, all legal boilerplate aside, it seems to me that's ultimately the question we've got.
That is the question, and there is no bright line rule. It's sort of like Justice Potter Stewart's obscenity. I know it when I see it.
Right, and these are the kind of cases I always have the most trouble with because I'm not ever sure what I'm seeing when I'm
right.
looking at it. So
I can tell you the same evidence was presented to the co-defendant's case of Mr. Cates, and Judge Ofalou had the questions he posed to the prosecutor, and this is in our record, pages 19 through 28. Nobody testified in this courtroom what was in the box at that time. Sometime later, this box is found in the woods in no one's possession. It's got cocaine in it. So how does that go to the jury? It's been sitting in the woods. Who had it? Who put the cocaine in there? How does anybody know that cocaine was in defendant's possession 24 hours later? And finally, how does the Court of Appeals place the cocaine in that box on December 29, 2013? Well, we know the Court of Appeals did not place the cocaine in that box. The majority opinion said, no, that's too speculative. And that's what I'm arguing to this court. There's another fact that wasn't stressed below or really in the briefs that I think is important. And I think, as I was thinking about this case, I was thinking it was sort of like the doctrine of recent possession. If a car is stolen on Friday and the defendant is found with a stolen car on Saturday, this court has said many times that you may infer from that that the defendant stole the car. But there's an exception to that. And the court talks about interference of others. If there's a third party, so if the car's stolen on Friday at 8 p.m. and there's evidence from the state that a third party is in possession of that car at midnight, and then the defendant's found with the car, the state does not get the benefit of the doctrine of recent possession. And that's what we've got here. We've got a box that was handled by multiple third parties, and the dissent below, Judge Dillon, went to the same inference that you did, that Scrappy ran in and the state is arguing that put the box in the woods. But we know that's not true because Mr. Anzaldo, the state's star witness, said, I didn't see what was in the box on December 29th. The way they found the cocaine was Mr. Anzaldo, and this is not inconsistent with the state's evidence. It did come in the defense evidence, but it's not inconsistent. The way they found the evidence is Mr. Anzaldo went to the Alamance County Sheriff's Office and told a detective, you will find 2 containers of cocaine. One is a mason jar and one is a black box. So sometime Mr. Anzaldo either was in possession of that cocaine, saw the cocaine, saw where it was, or someone told him where those boxes were. Now, this was the following morning that Mr. Anzaldo told the Sheriff's Department that. And we know that the box and the mason jar was clear. There was no evidence from any source that a mason jar was involved the day before. And someone made an inference that they were found close together. They were found, the record in the evidence is they were found 75 yards apart. So that's a pretty big difference, and that's on page 271 of the record. Excuse me, not the record, the transcript. So we know Mr. Anzaldo had access to those drugs, or someone told him something about it. So just to assume that Scrappy's the one that put him in the woods is more conjecture.
To follow up on my learned colleague, Justice Irvin's statement about speculation versus reasonable inference here, these kind of cases are fact specific, and that's why it's hard, as you said, to draw a bright line rule. What circumstance do you think is most pivotal here that would make the distinction between speculation as you would see it and reasonable inference as the state sees it?
I think, and I often argue to jurors, that sometimes the absence of evidence is just as powerful and as probative as the presence of evidence. And here it's the absence of any evidence from any source, any witness, anyone, of what was in that box on December 29th. Now, the date of the indictment in this case is December 29th, 2013. So I agree with the state that that's the day we're looking at, not the day it was found in the woods dry after a heavy rain, when who knows who had access to it, but we do know third parties had access to it. This court has said the evidence must be real, it can't be seeming, and it can't be imaginary. And when you have to stand up and argue what ifs, we don't convict in our state based on what ifs. We just don't do it. I wish I could tell you, Justice Morgan, that there's a line and it wasn't crossed. I would be untruthful if I said that. It's a gut feeling. There's no evidence there.
So the pivotal aspect of this is, if I'm hearing you correctly, the weakness of the evidence of the state such that it does not rise to a level of being a reasonable inference. I'm just trying to understand where it is when you say that the absence of evidence, yet there is still circumstantial evidence. Are you saying the circumstantial evidence is not strong enough, or are you saying there's not enough circumstantial evidence, or what is it?
The only circumstantial evidence that there was cocaine in the box on the December 29th is because there was cocaine in the box on December 30th after Mr. Anzaldo had either had access to it or someone told him something about that box. Because remember, he didn't look in it on the 29th, but he went to the sheriff's department on the 30th to tell them there was a box there with cocaine.
Now, does it make sense that he would have put the cocaine in the box and then gone to the police and said, oh, by the way, if you go in the woods, you'll find this box. It's got cocaine in it. Isn't it more likely that whatever cocaine was in the box was there before?
Before when?
Before he went to the police department and said, hey, if you go in the woods, you'll find a black box with cocaine in it.
Clearly the cocaine was in the box before he went to the police department. But to answer, I think what you're asking is, why would he go tell him himself?
Exactly.
Right.
Why would he put it in there as opposed to it already being in there, which would be more
Oh,
likely?
I don't know if he put it in there or if Scrappy put it in there, but Mr. Anzaldo knew exactly where the drugs were hidden because he told the police, you go here and you'll find a black box. If you read the testimony of the sheriff's deputy that testified in the defense, which is not inconsistent with the state's evidence, Mr. Anzaldo said the black box can be found here and the mason jar can be found there. And that's where they sent the dogs into those two grid areas to find it.
But aren't we asking how the drugs get there? In that the question, were they there before or did someone put them in there in the interim? That seems to be the thrust of Judge Dillon's dissent, where he says it seems unlikely that Scrappy would have left the woods, filled the box with over $100,000 worth of cocaine, returned to the woods near the place of the shooting, and abandoned the box and cocaine. He seems to say that it's common sense that with the drugs in the box, that they would have been, that the box would have been in the same condition as it were on the day before. That those are the reasonable inferences to be drawn.
And what defeats that inference, Judge Dillon's inference is Scrappy ran into the back, put the box down, and it laid there until the police dogs found it. What defeats that inference is that the box was bone dry after a heavy rain the night before. So something else happened, and the state asked this court to guess what that was. But we know it's not Judge Dillon's inference below because we know that box was bone dry after a heavy rain. And we know Mr. Anzaldo knew something about other cocaine in a mason jar. Now, a part of your question is it doesn't make sense that I think you used the term abandoned. Drug dealers often hide drugs off their premises. You know, there's many cases in this court where they link a marijuana field to a house because of the trail that's worn between the grower and the house. I mean, they hide things off the premises. So that's not unusual.
Let me ask you a quick question about the dryness of the box. I think you're saying, tell me if I'm wrong, because that could be, that it's not a reasonable inference to draw from the fact that the box was dry, that it was in the same condition the day before, including its contents.
What I'm trying to impart, not well, is the fact that the box is dry indicates it was not there during the heavy rain the night before.
And that's what I'm getting at, is what is a reasonable inference to draw from that, if not what the state is arguing?
Well, the state is arguing, as Judge Dillon did below, that Scrappy ran off into the woods, left the box, and abandoned it. The heavy rain defeats that inference. I would be absolutely guessing if you asked me. All I can say is the box was put there after the rain. That's the only inference I could draw from that, and that it had cocaine in it because the dog sniffed it, found it, and the police officers found the cocaine. But as to who put it there, there's no fingerprints, no DNA, because the dog sniffing destroyed all that. So I can't, I could come up with guesses, but that would be it. I wouldn't call them inferences.
Well,
Am I hearing, just a quick follow-up, am I hearing you correctly that your argument is basically that there was no evidence whatsoever of what was in the box on the 29th?
That's correct.
And that the state is asking to be allowed to draw an inference from nothing?
Correct.
Okay. That doesn't include what happened the next day? That you can't leap to what they found the next day because you can't draw that inference?
That's correct. If I was going to sell you a watch and I had a box with a watch in it today, and you said, well, I'm going to go home and think about it, and then the next day I'll come back with a box and give you the box, you're going to look in there and see if that watch is still there, because who knows if it's still there. Things change in a day, and there's no evidence of what happened between the time Polo was shot, Scrappy running into the woods, and the box being found, except there was a heavy rain and the box was dry. I mean, this is a great law school question. I love it.
And again, the question is it speculation or are these inferences? Because that determines if it goes to the jury. Clearly, the jury believed the state's theory. Clearly, the jury didn't believe, for whatever reason, that the box being dry meant anything. And clearly, the jury believed that what was found in the box the next day had been in the box the day before, enough to say that the defendant had possessed it knowingly.
I wish I could disagree with that, but I can't, because that's obviously true. But remember, every case that comes to this court based on sufficiency of the evidence, every single case, a jury has found otherwise. So the only time an appellate court renders a decision on sufficiency of the evidence, and you serve as the gatekeepers here, you have to decide whether there is sufficient evidence, because sometimes, believe it or not, jurors make mistakes. If I may have just a moment. If the court has no further questions, what I would ask is the court remand to accept the conclusion of Judge Ofalu in the co-defendant's case, to accept the conclusion of the majority Court of Appeals decision below, and remand this case back to the Court of Appeals or to affirm the Court of Appeals finding that there was insufficient evidence. Thank you very much.
Thank you. As you go.
Beginning with Mr. Ferguson's first point about waiver, the state is not asking this court to change the law in any particular way. The state is asking this court to restate that a defendant has to make a motion to dismiss based on the sufficiency of the evidence in order to preserve that for appellate review. Defendant has not made a general motion to dismiss based on the insufficiency of the evidence.
This was something I was going to ask you when you were finishing up your argument last time. The transcript, at least as I understand it, indicates, among other things, in moving for a directed verdict, that the defense counsel said, along with that, by not being found until 18 or so hours later, the last that we know is it's in the possession of some individual by the name of Scrappy. We, the state, has not been able to produce any evidence of what occurred between the time that he took possession of the box and the time it was found the next morning in a totally different location. Now, why isn't that essentially the argument that Mr. Ferguson just made in the second half of his presentation to us?
Your Honor, it's being argued in support of his motion to dismiss based on the insufficiency of the element of knowledge. That's why, just because it's the same evidence that can be marshaled to show or to bring to bear on the question doesn't make it the same argument.
All right, say that again.
Sure. He's pointing out what he has perceived to be weaknesses in the state's evidence. And he's saying that to say this is the evidence that the state is offering to show that defendant knew that there was cocaine in the box. And that's everything that he has said has led to that. He continues to come back to that.
If the purpose of the motion and the purpose of interpreting Rule 10 as the state is attempting to argue, isn't that to put the trial court on notice as to what the defendant is contending so that the trial court can appropriately address the defendant's argument?
Yes, Your Honor.
Why doesn't the language that I just read to you raise the question with sufficient specificity for Judge Harden, in this case, to have known what the defendant was arguing?
Because he doesn't connect it to the element of possession. He connects it solely to knowledge.
So is your criticism of the argument the fact that the defendant didn't say, now I'm moving on to a separate argument?
Not solely, but...
Well, is it in part?
Yes.
So the defendant has to get up in order to make a sufficient motion and say 1, 2, 3, 4?
That would be one way he could do it. He has to do something.
Can you do it?
He could also say, I make a motion to dismiss based on the insufficiency of the evidence of every element of every charge.
Is there any case that's ever required that level of specificity before?
Well, as defense counsel pointed out, Benson did require that the defendant direct his motion to each charge he wished to challenge. And when he had not done that, that argument was held to be waived. But as far as the specific elements, no.
So is Mr. Ferguson correct in saying that you're asking us to hold something that we've not held before?
No, Your Honor, because I don't believe that defendants in those cases had argued a specific motion to dismiss in the court below. That's what the defendant has done here, is he's argued a specific motion to dismiss. And the ground for that was the insufficiency of the evidence to show that defendant knew cocaine was in the box. He did not make a general motion to dismiss, which would have preserved a challenge to any of the elements. And I can see that I am out of time at this point.
Thank you, Ms. Euchre.
Thank you.
Thank you all, counsel, and thank you so much for traveling here to be a part of this historic argument today. Madam Clerk.
All rise. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess for 30 minutes. God save the state and this honorable court. Good morning. Thank you all for joining us this morning. We had a great first session earlier today. Before we get started, I wanted to tell you a little bit about the court system here in North Carolina. I'm Amy Funderburk. I'm the clerk of court for the Supreme Court of North Carolina. Now, our state court system was established by the Constitution of North Carolina. Our courts exist to protect the rights of the parties and to resolve disputes between parties. Now, courts hear two types of cases, civil and criminal. Criminal cases are instituted when the prosecution believes that they can show beyond a reasonable doubt that a particular person has committed a particular crime. Defense attorneys will present any evidence they have that they believe casts doubt on the guilt of the defendant, and they also present any legal arguments that they believe supports their position. And they'll also point out any legal mistakes that, in their opinion, the prosecution has made in the case. Now, under both the U.S. and the state constitution, generally a person accused of a crime has a right to trial by jury. Juries determine facts. They weigh all of the evidence before them, and they come to a determination about what they believe actually happened in the case. They do not decide what the law actually is. Criminal trials, which our first case this morning was a criminal trial. Criminal trials end with a jury verdict, either guilty or not guilty. If a defendant is found guilty, they're sentenced to some type of punishment, which could be a fine, probation, it could be imprisonment. If the defendant is found not guilty, then they're free to go. Civil cases, the other type of cases heard by the court, are what most people think of as lawsuits. These cases involve one party suing another party. These are usually private parties, but the government can also sue or be sued. The suing party is called the plaintiff, and the party who gets sued is called the defendant. Usually the plaintiff wants money from the defendant to compensate for some type of harm that they claim the defendant has done to them. But you can also sue to force someone to do or not do something, for example, to abide by the terms of a contract. Unlike a criminal case, a losing defendant in a civil case is not subject to being imprisoned. Civil cases end in a judgment, which establishes whether the defendant owes something to the plaintiff, and if so, either what or how much. Now, after a trial, whether that is a civil or a criminal trial, the losing party is entitled to an appeal. There are two levels of appellate courts in North Carolina, the Court of Appeals and the Supreme Court of North Carolina. Now, appellate courts don't hold trials. Instead, they review what happened at the trial court to see if all the proper procedures were followed and to ensure that there were no legal errors. Lawyers conduct arguments, which is what you're going to see today. The lawyers will lay out the issues that the court must decide, and they'll describe why they believe their client should win the case. Appellate courts specialize in determining questions of law. They will typically leave the determination of what the facts were to the trial court and focus on what the law actually is. They could be interpreting a state statute. They could be interpreting a portion of the state constitution. All cases are guaranteed at least one appeal, except for very serious matters, such as when the death penalty is imposed. The first level of appeal is to the Court of Appeals. The Court of Appeals sits in panels of 3 judges, and they decide their cases by majority rule. A second appeal is only guaranteed to the state Supreme Court if the Court of Appeals judges disagreed as to what the outcome of the case is or should be. Otherwise, the losing party has to petition or request that the Supreme Court take their case. And unlike the Court of Appeals, where judges sit in panels of 3 judges, the state Supreme Court sits in a full panel, and we have 7 members of the Supreme Court. Today, you're going to have the chance to observe an argument in front of the court. Each party has 30 minutes to make their argument to the justices, and it goes by very fast. You might think that's a long time, but it's not going to feel like it, is it? No, it's going to go by pretty quickly. We normally sit in Raleigh, but in celebration of the 200th anniversary of the Supreme Court of North Carolina, we're traveling throughout the state and having the opportunity to bring the court to you locally. I hope you enjoy your time here with us today and enjoy seeing the presentation. And at this point, I'm going to turn the microphone over to Associate Justice Jimmy Irvin so he can talk a little bit about his road to the Supreme Court.
Thank you, Amy. The first time they asked me to talk about my road to the Supreme Court, I'm the only member of the court that live in Morganton. I live outside Raleigh. I live in Morganton. And so the quick answer to that question is my road to the Supreme Court is I-40. Because every week I get on I-40 relatively early Monday morning and come back sometime later in the week when I've done all the damage I can do in Wake County. But it's a privilege for us to be here today. When we first got permission from the General Assembly to sit outside Raleigh in connection with the 200th anniversary of the creation of the court, we thought internally about the kinds of places that we wanted to go, recognizing that we couldn't go everywhere. And one of the locations that we early decided that we wanted to come to was Salisbury because of the history of Salisbury and its importance in the court system. I suspect most of you know this, but in Revolutionary North Carolina, there were 6 towns in the state in which the then highest court in the state, the Superior Court, sat, and this was one of them. This was the westernmost one. And I'm aware of the history of the county because my grandfather, when he was in the history program at the University of North Carolina at Chapel Hill, actually wrote a paper that received a Sprung Award on the colonial history of Rowan County. And as a Burke County native, I guess I'm one of your children in a sense. So it's there were a lot of reasons we wanted to come here. In terms of one's road to the Supreme Court, mine's not that different than lots of other people. I'm probably the most typical member of the court at this point. I was a native of Morganton. I graduated from the public school system up there in 1974. Got my undergraduate education at Davidson down the road a couple of counties over. Went to law school at Harvard and then came back to my hometown of Morganton in 1981 to practice law. Did that for almost 18 years and had a pretty general practice that over a period of time gravitated toward the very arcane area of utility law and appellate work. And that gave me the strangest practice in North Carolina, but it was actually pretty good because you could move from one thing to another and not get too bored with what you were doing on any particular day. I was actually appointed to the Utilities Commission in 1999 by Governor Hunt and served on that body for a good number of years. I remember coming down to hold a hearing here at the time that Duke built the combined cycle plant out at the Buck Steam Station site and had a very interesting evening learning about the history of the Dan River crossing because there were some people that were concerned about the site of the plant. And I've since read about it. It was an interesting thing, and that was one of the nice things about being on the Utilities Commission. Again, you found out lots of things about lots of different parts of the state. In 2008, I ran for the State Court of Appeals and was elected to that body and served there for 6 years. And as my brother, who is one of Judge Wagner's colleagues on the Superior Court, said, waged war upon the law for 6 years. And then ran for this court in 2014 and managed to fool enough of the voters to get elected to that court as well. And so I'm your typical move from start out in private practice in a relatively small town in North Carolina, which is, used to be the standard practice to this court, then went into a lower level of the judiciary and finally got here. And so it's a great privilege for me to be here with you today. I appreciate your tolerance in listening to me, and we are grateful to the town of Salisbury and to Rowan County for having us. Thank you very much.
Thank you, Justice Irvin. We'll be getting started with our second oral argument in just a few minutes. At this time, if I could remind you to either turn your cell phones completely off or put them on silent, I would appreciate it. And I would like to say thank you particularly to Carolyn and your team that has helped us put all of this together. We've had a wonderful time in Salisbury and are very, very grateful to everything that you have done for us and all the planning that you've put into place to make this happen. You were very fortunate to have the clerk that you do. Both of your clerks have fondness for you as well, Jeff. But thank you again for allowing us to be here with you. And I hope you find our oral arguments very interesting. We'll be getting started in just a few minutes. Thank you.
Excuse me for not getting up.
Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. We are thrilled to be commemorating the 200th anniversary of the Supreme Court of North Carolina right here in historic Rowan County, and we have been wonderfully hosted and so much appreciate everybody for their graciousness and wonderful spirit in making sure that we have had a really fantastic time here. I'm Sherry Beasley. I'm the Chief Justice. To my right is Paul Newby. To my left is Robin Hudson. To Justice Newby's right is Justice Irvin. To Justice Hudson's left is Justice Morgan. And to Justice Irvin's right is Justice Anita Earls. The court calls Hamlet HMA LLC versus Hernandez.
Good morning. Thank you, Your Honors. May it please the court, my name is Will Freeman. I'm here on behalf of the appellant, Sandhills Regional Medical Center. Before we start, I would like to take 1 minute and compliment opposing counsel, both here and at trial, and the court and the clerk and all the staff at all the levels who have shown that you can follow the rules and be zealous, very zealous, advocates for your client, but still be courteous. It's just been professionalism at every level, and it's worth noting today that's the case here, and thank you. Turning to my argument, though, this case is about whether Dr. Hernandez's claim against my client, the hospital, under the Unfair and Deceptive Trade Practices statute can stand. And the statute in question in its current form was enacted in 1977. And in enacting the statute, the legislature specifically excluded from its reach claims for, quote, professional services rendered by a member of a learned profession. And as this court said in Sykes this summer, and other courts have said before, the legislature really is establishing a two-part inquiry here as to whether the learned profession exception, sometimes called the learned profession exemption, applies such that a claim by Dr. Hernandez or anyone can be maintained under the Unfair and Deceptive Trade Practices statute. So, quoting from the Sykes test, first, quote, first, the person or entity performing the alleged act must be a member of a learned profession. And I don't think there's much dispute in this case that my client as a hospital satisfies that first Sykes inquiry. The second prong or inquiry that Sykes set out for us was, quote, second, comma, the conduct in question must be a rendering of professional services. And I think that's the inquiry and the prong where the Court of Appeals, the trial court, everyone has wrestled in this case. So that's where I'd like to focus my argument. Do the activities here in question constitute the rendering of professional services for a hospital? And I think of this sort of in 5 spheres. And, Your Honor, I apologize. I'm nervous, and I forgot to reserve any time for rebuttal. If I could, at this point, a little bit late, reserve maybe...
Let's go ahead, right ahead.
10 minutes? Thank you very much. The sort of 5 spheres where I think it's important to talk about that second Sykes inquiry are the starting point from Sykes and the case law is that this is a broad exception. Quote, exception for medical professionals has been broadly interpreted. And the second sort of lens that we look at this issue through is the language that the courts use when they're analyzing situations. In the Burgess case, favorably cited by this court a few months ago, does a matter affect health care? In the Wheelis case, also favorably cited by this court in Sykes a few months ago, does it regard, quote, ensuring the provision of adequate medical care? Cameron, does it regard assurance of good health? The Zaldivar case at the Court of Appeals, does it place a limitation on a defendant's ability to provide medical care? And then in Sykes, the court looked at whether the actions were, quote, sufficiently related to patient care. So we have this broad standard, this broad language being used by the court. The third sphere that I think illuminates how the court can look at whether or not this second test is satisfied is the legislature and what it knew and its actions and what has happened. And as noted in the state of North Carolina's amicus brief, the previous incarnation of the Unfair and Deceptive Trade Practices statute was amended in response to this court's finding in the J.C. Penney case that debt collection activities were not within that statute. And the J.C. Penney case came from common law. And the legislature wanted to overturn that opinion, but did not want to overturn it for learned professions, and it specifically carved out this exemption for them. And so, and no amendment has occurred since 1977, even though it's been decades now of case law at the appellate level, certainly. In 1970,
so let's just kind of put it in the big picture. So your client recruited the defendant to come to provide surgical services. Part of the agreement, 36 months. He only worked for just over 18 months. They had this disagreement. In the midst of the trial, it seems like the plaintiff had a fraud claim, but then also an unfair and deceptive trade practice claim, somewhat related to, well, you kind of got me up here under false pretenses, and even if I had signed the contract that I was asked to sign after 18 months, that it was somewhat illusory because there was a you could have fired me for no reason clause in there. And it seemed to me the trial court really wrestled with, okay, I'm going to let the fraud claim go forward. I don't want us to get off the main issue in front of the jury with regard to was Dr. Hernandez competent or not? Are we going to get into, well, his failure to attract patients was really his fault, not so much the area, if you will. Can you comment about, I guess, the fairness of the fraud claim being presented to the jury, even though not in the context of an unfair and deceptive trade practice claim?
Yes, Your Honor. And if I can just back up just a little bit to answer your question a little more deeply than that. I'm the plaintiff. I actually brought suit. These are counterclaims by Dr. Hernandez against me.
Right.
Well, the hospital. I apologize.
No, that's good.
And this is something that is difficult to discern from the record, but I think I tried to lay it out in the brief. Is the case sort of focused initially on this? You lured me to an area where I could not thrive, and we were going to say the reason you didn't thrive was because of these medical issues, and you correctly, Your Honor, just said the court didn't want to be having all this evidence in the juries about in front of the jury about the physician's skills, and because of the court's sort of prodding, the case sort of focused a little bit to the need in the community, and that's why we had 3 physicians called near the end of the trial, Dr. Nascimento, Dr. Adia, and Dr. Mangum Smith, about whether or not the community could support a surgeon. But then the case kind of shifted a third time, and the court really wanted us to focus on the idea of, you brought me here and knowing halfway through the 36-month period, you would give me this contract that had a termination without cause provision. And that was the badness, the wrongful act. And that's sort of where the court ended up its focus. And I know that's not exactly the question you asked, Your Honor. I'm not trying to avoid it. And so as presented to the jury, those were sort of the emphasized facts of the trial. The others were still there. They'd heard testimony on them, but the court really was pushing us hard to get away from these physician issues and focus more on those. And in fact, after the directed verdict was granted in my favor on the UDTP claim, the court, just a page or two later in the transcript, says something like, let's not talk about the need, let's not talk about the sort of bringing him down here under false pretenses, let's focus more on this contract, this luring, this 30-day secret issue. So I think your question is, let's discuss how the fraud claim got sort of tied in with those 2 claims. And I'm not sure exactly how to answer it. I guess one of the issues, the themes, and this is in the amicus brief of the North Carolina advocates, is, we got to give this guy his day in court. Well, he had his day in court on the fraud claim, and he raised lots of defenses that were rejected by the jury to the plaintiff's breach of contract claim. And they are different claims. They are different actions. But if the jury had returned a verdict on both fraud and the unfair deceptive trade practices statute, I think I would have moved for an election of remedies. But it didn't happen because we won the fraud claim, and the unfair deceptive trade practices had been directed verdict had been granted. And I think that answers your question, but I'm not.
Well, one question I had mulled over, and I don't claim to be an expert in this area of the law at all, but I went back and looked at the complaint, and the factual allegations in the complaint on the fraud claim and the unfair and deceptive trade practices claim are virtually identical. What should we make of that fact, if anything, coupled with the fact that the jury rejected it?
I think it gives us some confidence in upholding the trial court's determination, because the sort of arguments he made got presented to a jury. He had his day in court, and the hospital prevailed. And so we don't have to feel like we've silenced a person from making an argument. And also, if I can, Your Honor, I'm sorry, I see a look on your face. I don't mean
I make faces when I think, or at least when I attempt to think.
And I had actually made a motion and said, you can't raise all these issues you're making, and the trial counsel tried to amend the complaint. And the judge said, we're not going to do that on day 8 of a trial, but I'm going to let them make some of these arguments. We're going to, between the pretrial order and the complaint, I think there's enough here about these 30-day provisions in a recruitment and an employment contract.
But just following up for a moment on this issue of the difference between a fraud claim and an unfair and deceptive trade practices claim, certainly the elements of the claims are different.
Absolutely.
And isn't part of the reason why the legislature thought it was necessary to have an unfair and deceptive trade practices claim and created the avenue was because the common law fraud claims were not solving the problem of deceptive practices in commerce?
I think that we can agree that is probably a factor in the legislature's mind. We don't have a true, legislative history and record, but certainly that point is made in the amicus brief. They are different claims. They do have different elements, and they've different. I'm sorry.
No, please finish your answer.
I think I largely agree with you. I just sort of think in your gut when you're like, gosh, I hate to deny a guy his day in court. Well, he got his day in court. That's sort of my point. I know it's not quite the answer, though.
Well, I do think he didn't get his day in court on the claim that the legislature put in place because fraud claims were not working in these contexts. But let me go back to your initial point about how broadly the learned profession exception should be read. And I just want to understand, do you agree with the amicus brief that was filed by the Hospitals Association that there are some activities of a hospital that would not be covered by the learned profession exemption? Or is it your view that whatever a hospital does, it's related to patient care and therefore it's covered?
Let me back up just a little bit. I think that this court has said there are 2 tests. You've got to be a member and you've got to be rendering professional services. So there would be circumstances where a hospital would be doing an activity that isn't the rendering of professional services. Does that answer your question?
Yes.
Okay.
And then just let me follow up to that. Does the rendering of professional services have to be done by a professional? In other words, I believe that there was no evidence in the record that Jim Whitaker and Mike McNair, who were negotiating this contract with the doctor, that there's no evidence that either one of them were doctors.
Well, if I could say the short answer is non-MDs can render professional services, and entities can render professional services. And I think that's the first Sykes inquiry is this thing, and the court used the language person or entity, a member of a learned profession. And so the first test is it a member of a learned profession? A hospital, that's my client. The Shelton case said hospitals are a member of learned professions. This court has favorably cited that the Sykes case was an intermediary in-network chiropractic company, and it was protected by the UDTP. In the Cameron case, it was a hospital. In the Wheelis case, it was a hospital. And so a hospital acts, it's a thing, it's a company. It's not a person. It acts through agents. And so there's never been a sort of third prong is, are you a member of a learned profession? And is everyone within you a member of a third learned profession? And was it the rendering? I think to sort of say it has to be a hospital and everyone involved has to be a physician or an attorney or a member of the clergy, that's a little bit more, I think, than the case law supports. I think it's more, this is the CEO of a hospital doing what a hospital does, which is recruiting physicians into the area.
Well, in the fact pattern that we have here, how is it that the learned profession exception would apply in this employment contract context? It appears as though, on the surface at least, it happens to be an employment contract that just happens to be between two parties who are members of the learned profession, hospital and doctor. So does that inherently mean that because it was an employment contract, that because each party belonged to a recognized learned profession, that inherently and automatically makes it a learned profession exception situation?
Your Honor, I think you're saying because both parties were members of learned professions, is it just automatically apply? I don't think so. Does that answer your question?
Oh.
But then, I'm sorry.
Well, yes, it does answer it, but I'm wondering, are you going far enough with talking about the breadth of the exception to say then that because both parties belong to the learned profession, then the exception is automatically going to apply, despite the fact that overwhelmingly the basics of this contract smacks of employment?
If I can give you a little bit of a long answer, Your Honor, I think when we sort of lay the facts of this case onto the law, which is the broad interpretation, my client is a rural hospital, and there was testimony in the record that the mission of my client was to recruit physicians into the community, not just surgeons, but any physician. And the mission was to provide quality health care for the community, for Hamlet, North Carolina. And this was really important in Hamlet because almost 80% of the people were on Medicare or Medicaid. And Mr. McNair, the CEO at the time who recruited Dr. Hernandez, Mr. McNair testified, patients can't afford to travel. They don't like to travel. And he said, I felt it was my obligation to have a surgeon here. And as part of my mission, Mr. McNair says, part of my mission to have a surgeon in a community, I surveyed the community. I looked at demographic data and zip code data. We had annual surveys of what physicians were needed. I spoke with other physicians. I noted people were having to leave the community. I looked at the historical need for surgeons, and Mr. McNair and Mr. Clay, the current CEO at the time of the trial, both said in their decades of healthcare, this community needed a surgeon. And that's not just the mission of the hospital, it's also a mandate.
I get that.
Okay, Your Honor, I'm sorry.
And that's laudable, obviously. But in terms of talking about the learned profession exception, since this was an employment contract, an employment opportunity for the doctor to come, and it was an opportunity for the hospital to provide someone who was going to be stable and available for the community, how is it that the learned profession exception applies in terms of the rendering of professional services, which is ultimately what we've got to answer? If this was an employment contract that happened to involve medical providers and does not therefore exclude this professional exception to apply?
Your Honor, I think that a hospital, that's what a hospital does. It renders services by having a physician there at 3 a.m. when your appendix ruptures and you need someone there who's a surgeon. That's what a hospital does. It has a surgeon there who lives nearby. That's how it operates. That's what a rural hospital does. That's its rendering of profession. That's one of the core sort of things a hospital does is have a doctor there when you need it. And so not to say that the mechanism by which it satisfied that mission wasn't a contract and an employment contract. I agree with you there, Your Honor, absolutely. But in this case for a physician, the rendering of services by a hospital is getting a doctor there. And that's from the mission of the hospital and also from the statutes and regulations and case law of this court.
Hypotheticals can be dangerous, but let me attempt one to try to talk about where I'm trying to go with you so I can have what I need. If a plumber had come to the hospital to fix some deficiency in the water system, the hospital is there obviously needing water to do some of what it needs to do. Let's say that the plumber was defective or deficient in terms of what he or she happened to render. Is there a learned profession exception because the hospital is involved in rendering professional services, and therefore, if something's going on with a counterclaim from the plumber, that the hospital can say learned profession exception, even though this is something that is more in line with services rendered as opposed to professional services from a hospital medically?
And I think Your Honor said it at the end, it's important that there has to be a counterclaim from the plumber back against the hospital.
I was trying to make it relevant
No,
to what
I
we got
understand
here.
totally. And so, depending on the nature of the counterclaim, it could be, but it's difficult for me to think of a scenario where that would be true. And if I can, I think Your Honor is mostly correct, is what I'm saying. But I suppose we could think of some wild set of facts where it relates to professional services. But that's where the Wheelis case really kind of helps, I think, understand this, is because in that case, and the court opinion says, a whistleblower, anonymous whistleblower for malicious purposes to hurt a physician, went and broke a law, criminally accessed records, sent them to the board, and then when the hospital is sued for that anonymous whistleblower's criminal action to hurt the physician, the court in Wheelis, and that's an appellate court decision, said, hey, narrowly, this is about a crime, and this is about a malicious activity just solely designed to hurt a physician. But if you step back and take the broad view, then it's about health care. It's about, and it was sent to the medical board. Maybe it was sent for a horrible purpose and an illegal purpose, but it's about medical care. And that's what we have here, is we have we need a doctor we need a surgeon in the community, and we went out and got one. The specifics of the contract and whether or not we should have told the doctor about the 30-day, that there was going to be a 30-day provision, whether or not he knew subjectively whether there was one based on his history. That's sort of the minutia, and always a careful drafting counterclaim or claimant is always going to carefully draft it so narrowly, and the court says, no. We're talking about a hospital having a surgeon in the community, and that's what the trial court ultimately came to, and the dissent in the Court of Appeals said, hey, you're being sued by Dr. Hernandez for getting him here. You're being sued for 17 days of being on call. You're being sued for all these issues about staffing, I think is the term used, staffing a hospital. And that's what this case is about. And it's important to take that broad view and look back and say, yeah, this is about a doctor being here.
Mr. Freeman, I just wanted to let you know you're into your rebuttal time.
If I could just
Sure.
say a few more
It's your
minutes, Your
time.
Honor. I think there's sort of this focus on this business deal. This was a terrible business deal for the hospital. Dr. Hernandez got more than $900,000, and he could refer patients to any hospital, even a competitor. Dr. Hernandez had the contractual right to be on staff at a competitor's hospital if he wanted to. He was going to get $900,000 more than, no matter what, right? We just wanted him here in the community, and that's why the contract ties him not to the hospital, but to the community. It says, we're going to give you more than $900,000, and all you got to do to get it forgiven is stay here, be here, open a practice full-time, don't turn anybody away if they're on Medicare or Medicaid, don't discriminate, and keep privileges. Take some call at our hospital, take some unassigned patients, and we will not make you repay that $900,000. And when remember there was a 36-month period, when the halfway point had gotten, we gave him another contract that he had a choice. He could get $325,000 a year annually for the next 18 months. We might have terminated it, but we might not. We'll never know because he didn't accept it. But regardless, we also gave him an independent contractor agreement that was going to give him a cushion of $200,000.
Is there ever a set of circumstances under which the extent to which a contractual arrangement did or did not involve the rendering of professional service would involve a question of fact?
As I read the case law, there's been 10 opinions
And I've read all of them this morning.
We'll go, there's been 10 opinions that are published by the state court, appellate courts, that involved the rendering of professional services, and none of them went to the jury. They were all decided on a summary judgment, motion to dismiss, or directed verdict.
Do you infer from that fact, the fact that none of them came up in a context other than that, to mean that there can never be a question of fact that would govern whether the learned profession exception applies?
I think you sort of fall back on the standard, which is the trial court's directed verdict standard, right? They've got to take all the...
I understand that's what we've got here, but I mean, the real issue that we've got before us is was the trial court correct in directing a verdict in your favor with respect to the Unfair and Deceptive Trade Practices Act claim on the basis of the learned profession exception?
I think the trial court had the right to be the gatekeeper on that claim, but I don't know that that's directly answering your question, because it's almost, it's not like a Fry analysis, but it's almost like the trial court can survey this and say, I see here learned profession issues, and therefore I'm not going to let this go to the jury. And that's how, 9 opinions have not allowed to go to the jury. Only 1 has thought that it should have gone to the jury, which is the Court of Appeals majority in this case. If I can, just briefly, Your Honors, I'd ask that the trial court's decision be reinstated and that the Court of Appeals majority opinion be overturned. And I'd like to reserve the balance of my time for rebuttal unless there are any more questions at this point.
Thank you, Mr. Freeman.
Thank you very much, Your Honor.
May it please the court. My name is Mark Hayes, and I represent the appellee, Dr. Hernandez. Professional services rendered. Those words are the polar star of this case because they are the words from the learned professional exception itself. Professional services rendered. Each one of those words means something. Don't let Hamlet distract you from those 3 words. And its very first distraction is going to be about this altruistic mission, about how it was a small-town hospital and et cetera, et cetera. Well, that's a distraction, and it's also, procedurally speaking, untrue in this case because we're at a motion for directed verdict. This is just like for a motion to dismiss. Every fact, every inference is drawn in favor of Dr. Hernandez, not in favor of Hamlet. So when Mr. Freeman talks about, well, there was testimony about this and there was testimony about that, they don't get that benefit. They also don't get the benefit of just kind of cobbling policy ideas from the air about, how they're doing great things and hospitals are doing great things. They don't get that benefit. We're here at a motion for directed verdict. If this was an old Western, I'd put a white hat on my head, and I'd put a black hat on Mr. Freeman's, and knowing Mr. Freeman would probably wear.
And you both look really good.
Absolutely. Hamlet is not here to argue that it did nothing wrong. Hamlet is here to argue that it did something wrong, but it should get away with it. That's their argument. And get away with what? Well, Dr. Hernandez was making $325,000 in Maine as a successful surgeon. He saw an ad about coming down to practice in North Carolina. He responded to it. Hamlet said, set up this independent practice. Well, Dr. Hernandez didn't want to do that. He thought it was just going to be regular employment. He didn't want to take that risk on. Hamlet said, well, we have these studies that will show this practice is going to be successful. We'll have the patient need for you. It'll work. But that wasn't true. Those studies didn't exist, and that's coming straight from the complaint, which, again, we're assuming is absolutely true. The CEO, Mr. McNair, he's actually said in the testimony, and this is on page 889 of the transcript, he knew that the practice would be a financial failure. He said every practice that sets up down there is a financial failure. So Dr. Hernandez still wasn't convinced. He still thought, well, this is too risky. So he said, well, how about an employment option? You're asking me to have this 3-year commitment or I have to practice down there. How about if the independent practice doesn't go well? You let me come on as an employee making what I made in Maine, and you give me a contract with a term that finishes that 3-year commitment. Well, Hamlet says, all right, we agree. But the CEO knew, and this is on page 449 and 860 and 861 of the transcript, he knew they would not offer an 18-month contract with that term. He knew that they would offer a 30-day only contract where they can terminate him for any reason. And he also knew there would be a no-compete clause, which would put Dr. Hernandez in a complete catch-22.
Now, as I read your colleague's brief, at least, he indicates that the non-compete provision only did not apply in the event that there was a not for cause termination. Is that right?
In the event that there was a what kind of termination?
That there was a termination, but it was not for cause. It was just a causeless determination, and that's my word and not anybody else's.
Right. I think the inferences, again, the procedural posture here is so important. The inferences are what's actually going to happen. Because what happened, you don't know how the facts are going to work out and how things are going to be exercised.
Which is one of the reasons I asked the question of your colleague about whether there was a possibility of a question of fact here, and I was going to ask the same one of you, so right. You can have that while you're at it.
Right. There absolutely is, and I'll get to that when I'm talking about the plain text more thoroughly, but there absolutely is. So Hamlet put him in this catch-22 one way or the other. There's a discussion when Dr. Hernandez says, I want this contract, they say no. Dr. Hernandez says, well, I'll even work for almost $100,000 less if you'll just give me the term. They say no, we still want to keep this termination clause in there. Which, the only inference from that is going to be that they are going to exercise it. So the idea that Dr. Hernandez walked away from the table is kind of crazy. Anyway, so Hamlet, again, basically gets all the upside of they're going to make the money from the facility fees, the hospital stays, being able to pay their nurses to do things, but none of the downside of the losses that are going to happen with this practice that they know, again, by their CEO's own words, is going to fail. So the bottom line is we have deceit in contracting and advertising for the purpose of making money. And the question for this court is this a sort of claim for which the legislature intended it to go unchecked by the Unfair and Deceptive Trade Practice Act?
Let me ask you one further question, just because, your colleague got up, as you've already pointed out, and said that we were this altruistic, eleemosynary institution that was out there trying to do good for the community in Richmond County. Your argument is, no, they were out to line their own pockets at the expense of Dr. Hernandez. Does this all come down to how one ultimately determines this contractual arrangement ought to be characterized?
I think it ultimately comes down to the deceit in how this agreement was. But see,
he says there's no deceit. You say there's deceit. Do we have to find in your favor on the facts? One of the problems I'm having with this case is it looks to me like one side characterizes this agreement as one thing, and I won't use my own characterizations, and one party says the other, and both of you are acting, at least if I'm understanding your arguments correctly, maybe I'm not, in which case you tell me, but both of you seem to be saying it ought to be characterized either the way you're characterizing it or the way that Mr. Freeman is characterizing it. So does this come down to a question of characterization?
Well, we don't have to make that determination because remember the hats we're wearing. We're at a motion for directed verdict. I've got the white hat on. Everything in the complaint is in our favor. So if there's a characterization to be drawn, it's in favor of Dr. Hernandez.
As the answer to my question, it comes down to a characterization. There's evidence to support my characterization, and therefore I win?
I don't think so, Your Honor, because at a motion for directed verdict, we're not dealing with the substantive evidence of the claim. We're assuming it's true. Now, whether your inquiry
That's my ultimate problem, is that both of you seem to be arguing, in effect, that we have to resolve the merits in order to determine whether the learned profession exception applies.
Right.
That's essentially what I'm hearing both of you say in very different ways.
Right. And if I'm presenting it that way, absolutely I'm not. I don't mean to say that. The only reason I'm presenting these facts is so that this court will have a context for the sort of claim that it's going to let go unchecked. But again, we're supposed to be looking at the complaint as if it's completely true.
But if the rendering of professional services is supposed to be looked at broadly in terms of talking about the learned profession exception, while being at the directed verdict phase of the trial, why would the exception not then be broad enough in this employment contract situation, as your opponent is arguing, that because the hospital is endemically involved in rendering professional services, why would that not capture then the exception automatically?
Your Honor, I think the most direct answer to that is the exception is not to be interpreted broadly. And the state's amicus brief, and I know from my own time clerking with this court that the white-covered amicus brief sometimes gets short shrift, but I really commend to this court the amicus brief of the AG's office. They really delve into the policies, and they talk about how, first of all, there's this general rule in these sorts of statutes that these sorts of exceptions are narrowly considered. It talks about the AG office's own opinion that was issued when the legislature asked for an opinion about how this exception was going to be interpreted right when it was being passed. And the AG's office issued an opinion to the legislature and said very specifically, this is just it's actually said, I believe, is to be strictly drawn was the words that opinion used. When Mr. Freeman talks about it, the legislature meant it to be broadly interpreted. Take a hard look at those parts of the brief. There's no citation to anything about the legislature or to the AG's office. He's citing to Court of Appeals opinions, but nothing about the intent of the legislature.
Let me ask you a question about that. I'm sure that you know recently in Sykes and in a number of cases from the Court of Appeals, there's language to the effect that the exemption is to be broadly interpreted. Are you asking that we revisit and or limit our holding in Sykes or overturn it or distinguish it somehow?
I would read Sykes as observing what has happened in the Court of Appeals rather than commending that to happen. In Sykes, you had a unique situation where you had an entity that was entirely comprised of doctors, and so therefore, chiropractic doctors. So therefore, not only were they did they have that identity, but anything they did had to be acting at least, arguably as that. So you have that on one hand. You also have what this court, the words they used were that patient care was at the heart of the matter. And I feel like those two things gave us a kind of a broader look at how that case specifically should be resolved. But I would hope this case would be where we really articulate exactly how this test should be worked out. And that the first step for that is the plain text, professional services rendered. And the first place to look is services, the noun of that. Services mean, of course, you're serving someone. In a medical context, patients. So when we look at the complaint, the counterclaim, the unfair and deceptive trade practices counterclaim, let's look for talking about patient care. In Sykes, we have that. We have talking about patient care. We don't have that here.
Well, if the case law talks about on the appellate level here, Court of Appeals as well as Supreme Court, if the case law holds that the exception is supposed to be broadly interpreted, then we don't need to look to the legislative intent as a court system if we're satisfied with the declaration having been made and reiterated that it should be broadly applied. Would you not agree?
Well, broadly applied is going to give us some sort of general perspective, but that's not going to unground us from the language of the statute. And that's why it's very important to work through the words that we do have instead of just kind of walking in blindly and saying it should be broad and saying, is this a professional service rendered? The service here, looping back to that.
Quick question about that. What are we to make of or how do we use the opinion of the Attorney General regarding that language about that only those activities which distinguish an individual as a member of a profession, those activities are the only ones protected by the exemption?
Right. I think it goes to the plain text, I think, really resolves this. But falling through that, if you get to policy considerations, the first step is going to be looking at the AG's opinion because the AG, Mr. Morgan at the time, was the champion of this law. And so it just makes sense to look to them and see how are they wanting to interpret this exception since they were the ones that kind of got it on the books. And they use the words strictly enforced or strictly drawn, And that's in response to the legislature's inquiry about, hey, how should we interpret that? That's pretty on the nose.
And just a further follow-up about the impact of the AG's opinion. Do you agree with the state's amicus brief that that opinion actually sets out a three-part test? So there's the two-part test of are they a member of the learning profession, are they engaged in professional services? But then in assessing whether or not they're engaged in the delivery of professional services, the AG says we look at whether they're applying the unusual learning that they have as a professional, whether there's a confidential relationship, and then whether what they're doing is not purely commercial. Do you agree with that?
Your Honor, I think everything that's said there is completely consistent with what I'm going to lay out here. But I'll say if I were a law clerk that was about to write this opinion, and I wanted the easiest, most straightforward way to write this and articulate this, which our state needs, because this is, this court kind of really having a chance to clarify this issue, I would go straight to the plain text, those three words, and I think that covers everything that you mentioned, Justice Earls. Professional services rendered. Looping back to the services, here we don't have a complaint that talks about patient services or heart of the matter or anything. We have a complaint that talks about advertising, recruiting, and contracts. Furthermore, it has to be professional services. Every word has to have meaning. Only professionals, and we've touched on this already, only professionals can render professional services. Doctors do doctoring, lawyers do lawyering, plumbers do plumbering, I guess, but they don't do professional services. Whatever they do, it's not professional. And this court has very tightly...
You sure you want to go tell a plumber that?
That's right. Water runs downhill. This court has been very tight about who a professional is. There's lots of folks that we admire, teachers, nurses. They aren't professionals, apparently, for these purposes. And so when we're looking at these services being professional, it has to be done by people who are professionals. I'm not sure how anybody can, not practice law without a license if they're doing professional services and yet they're not a lawyer. Here, who's doing all of the relevant acts? It's a CEO, Mr. McNair. He's not a doctor. It's an administrator, Mr. Whitaker. He's not a doctor. Now, Mr. Freeman set up kind of a straw man about saying, well, we don't have to make the hospital, everyone in the hospital be a professional. Well, I agree with that. It's going to be a factual inquiry. What was the relevant act here alleged in the complaint? Was it something done by a professional that requires that professional skill, or was it something that wasn't? I thought it was very telling that when we heard Justice Morgan's question about the plumber, we really didn't get an answer to that, did we? Where are the outer bounds of this exception? And how is the hospital defining those? I'm defining them very clearly from, the policy statements from the Attorney General's office, but first and foremost, from the plain text.
Are you contending that this statute is clear and unambiguous and does not require interpretation?
I absolutely agree with that. I think
your view is this language on its face is clear, unambiguous, and can be applied based solely on a textual analysis without more in any case?
It's awful hard to ask a lawyer in any case, but...
I know I used to do it.
But I would say it's unambiguous. I would say if you asked the people behind me and you gave them some examples, I bet you they'd sort it out real solid between what's professional and what's not.
One thing, and I'm going to change the subject on you, so if you want to get back to it, bear with me. One of the things that, if you read the state's brief, it tends to suggest that 8 or 10 opinions of the Court of Appeals were wrongly decided. It can be read to suggest that this exception doesn't apply outside the malpractice context. I'm not sure that's what they meant, but they certainly suggested it. Do you contend that all 10 of those decisions were wrongly decided and that this only applies does not apply outside the malpractice context?
I would say that many of those opinions are called into serious question.
I'm sorry?
And I would say many of those opinions are called into serious question by the plain text, and that...
Are there any of them that you think were, that under your view of the statute were correctly decided?
Absolutely. Phillips, for example. A patient cannot bring a UDTP claim based on the doctor's alleged injurious treatment of her. That's on the nose. That's basically malpractice. That's what this exception by was meant to hit on. So that one would be fine. I think because there is something of a factual inquiry because of what is the relevant act here, in order to really evaluate, you have to go back in time and develop that record, and so it's unfair to say which ones would.
As the state, and I'll be quiet in a second, I've monopolized too much of your time, but the state's brief seems to suggest at least that the Court of Appeals misconstrued this statute from the beginning. You've urged us to pay close attention to it, so that's why I'm questioning you about the state's brief, even though I know you didn't write it and you're free to disclaim it if you want to. We also know that over the course of this 30-year or so series of decisions, the General Assembly has not taken any further action to modify the statute. After all, we are talking about a statute. The ultimate inquiry is the intent of the General Assembly. What are we supposed to make of the General Assembly's inaction in the face of these decisions? Your colleague mentioned that in his brief. If you responded to it, I didn't see it.
Right.
So what is your response?
So you're talking about 10 opinions over 40 years, none of which reached this court, some of which, as I've already identified, I wouldn't even have any problem.
One of them was affirmed per curiam, wasn't it?
Right. I don't recall. I'd have to look and see.
The Phillips case?
Right. Well, the Phillips case was the one that I said was spot on the nose I'd agree with. So absolutely. So you also are talking again about, why were unfair and deceptive trade practice claims enacted in the first place? Because of this great power discrepancy where plaintiffs couldn't get the relief that they needed from the traditional claims of fraud and breach of contract and that sort of thing. They couldn't afford to bring it without having provisions for like attorney's fees and treble damages and that sort of thing. You wanted to create a claim that would give power to some powerless folks in the face of large corporations that are really stacked up on lawyers. So I'm not surprised that a lot of these cases didn't make it further than they did, that they may have gotten settled. We don't know. I wouldn't read much out of the fact that this few cases, the legislature hasn't responded further. Looping back to it being professional services, again, nobody here was a doctor. Mr. McNair, Mr. Whitaker, not doctors. We don't ask that everybody here be a doctor. And this is entirely consistent with Sykes, where you had an entity that was entirely made up of doctors and so therefore was acting through doctors. And so arguably you're able to add that adjective in of professional services. And the final plain text word here, professional services, rendered. What does rendered mean? What's the plain meaning of rendered? It means to make or to cause to happen, not affects, not as integral to. If you all sit down, if this court sits down with people in your chambers and you ask, come up with 5 sentences that use the word rendered. An artist rendered a painting. A judge rendered a decision. Can we substitute affects? Can we substitute is integral? Does it mean the same thing or does it mean anything at all? An artist affects a painting. A judge is integral to a decision? No. Rendered means to make or to cause to happen. And the only people who make or cause to happen professional services are professionals. So unless the complaint is talking about professionals at this corporate hospital doing stuff, then it is not within the bounds of the exception.
Let me go back to the esteemed Justice Hudson's question that you didn't fully answer, which I think is going to give us a lot of guidance if you do. And that is based upon your foundation that the learned profession exception should not be broadly applied. Are you then asking us to reverse that line of cases that seems to suggest otherwise? Are you asking us to keep the law where it is and just not extend it to this particular case? Or are you asking for something else?
Well, Your Honor, I probably have unfairly taken the bait too much on policy considerations. Again, the touchstone is always going to be the plain text. The policy considerations about whether or not we say what's professional is broadly construed or narrowly construed. Is it setting an arm or is it making a report at a morbidity ward later? I mean, if this court wants to say that we are going to say what's professional is broadly construed, I don't necessarily agree with that, but that is in no way fatal to my case because here it is so clearly not professional services rendered by the fact that you have administrators and CEOs doing everything in the complaint that it really doesn't matter.
So you're not asking us to overrule any precedent?
It's certainly not necessary. I think that there are some Court of Appeals opinions that might have to be revisited, but there's nothing of this court.
And is that because the facts of this case are so different because of the fact that there were non-medical agents that were representing the hospital, or is there some other circumstance that you feel makes this matter different from those others?
I think the fact that you have the relevant actors here, the CEO and that mid-level administrator, are certainly not doctors. It makes it easy. You can just stop right there because they're not going to be doing anything professional.
I've just taken a moment and gone back through the complaint to look at the allegations made with regard to fraud and then made with regard to unfair, deceptive trade practices.
Yes, Your Honor.
And they're identical. And we have a jury verdict that says no on the fraud claim. Can you give us the best argument why that's not collateral estoppel?
Absolutely. Absolutely. First, procedurally, the fraud claim went all the way to a jury, and we are at a motion for a directed verdict. So we're talking about whether at its inception a claim should be able to push through as opposed to the fraud claim, which made its way all the way to the end.
So I'm talking now,
right, after
we've gotten a verdict from the jury.
Right.
And the exact same allegations were made to support two different claims. You have a jury verdict saying no with regard to that claim as it was characterized as fraud. Why would that jury decision that fraud did not occur also control the outcome of this claim were it to survive here?
Right.
I mean, I just envision it going back to the trial court and your opposing counsel making an argument, well, collateral estoppel, we've already had a jury consider these same facts to say no.
I think the most important thing is they have different elements, and the element I would really zero in on is you have a specific intent element on fraud that you don't have to have in unfair and deceptive trade practices. So a lot of times in these entities, the CEO knows this is going to be true. The administrator is kind of, maybe he suspects it. I mean, you can have deceit and unfair dealing that maybe is hard to pinpoint on the nose of this is specific intent to deceive, where an unfair and deceptive trade practice claim is going to go through and maybe a fraud claim wouldn't. I think it's also important to note that, Hamlet is not a 100% winner on this fraud claim. They wanted $1 million back. The jury split the baby a little bit and awarded them about $450,000. And that's a separate issue that's not before this court about whether that might have been a compromise verdict or not. But if we are going to infer anything about what happened with the fraud, which I think is inappropriate for procedural reasons because of the directed verdict, inappropriate because of the difference in the elements, specifically specific intent, I think you can also just look at the number and see that, okay, there was room for this jury felt some, if we're going to set the law aside and just go with what was the jury's gut feeling, they were closer to my client's number of 0 on that claim than they were to their number of $1 million.
They precisely answered the question with fraud with the word no.
Well, the jury said on fraud, again, I would just cite back to my example of the specific intent is just a different standard and the procedural is just a different standard. Finally, I'm not going to spend too much more time on this, on the policy considerations, because we've touched on it a number of times. But I would ask, just kind of circling back to Justice Morgan's questions about the plumber. Mr. Freeman has admitted that there's something outside the scope of this exception, something. I'd love to know what it is. He's got a few minutes. I'd love to know what it is, and I'd love to know how he articulates it. Is he going to articulate it based on a bunch of Court of Appeals opinions, which is kind of the only thing he has? And if we're going with the Court of Appeals, by the way, we prevailed at the Court of Appeals, so I would ask this court to affirm. But otherwise, if we're going to set them aside, where's his argument in the plain language? Where's his argument in the legislative history? Where's his argument in anything that tells me here's where I draw the line? I've articulated a line for this court. Professional services rendered explained how each of those words means something and therefore doesn't mean something. Where's their line? That's my challenge to them. My other challenge to them, and I'll touch on this briefly as well, is there any jurisdiction where this exception or anything like it has been interpreted nearly this broadly? To my finding, to the amicus brief of the state, to the amicus brief of the Advocates for Justice, that answer is no. And the hospital is basically saying, well, that's not our jurisdiction. When we look at those, and I admit that's not exactly where I want this court to look first, again, plain text first, but those exceptions, whether they're in black and white in the statutes or whether they're judicially created, sort themselves into two categories. One is basically the exception lines up perfectly with malpractice, or it lines up with things that are not commercial or entrepreneurial, which may just be a different articulation of the same thing. Here, the complaint is not something that could be spun as malpractice. And it certainly is commercial. We're talking about dollars and cents and contracts. So if we have, any informative persuasion from the other jurisdictions, again, it's only going to support our position. In sum, the professional services rendered. I just urge this court to have each of those words have meaning. Professional, the actors here aren't professionals. Services, are we talking about serving patients as we are in psychs? No. And rendered. All these words about affected, integral to, whatnot, they don't mean make. Only doctors, lawyers, professionals make professional services. With that, I will ask that you don't allow this corporation to use this exception meant to protect doctors against a doctor. Let this claim go forward and affirm the Court of Appeals. Thank you.
Thank you. Mr. Freeman, rebuttal.
Thank you, Your Honors. We don't have to resolve these claims on the merits to answer one of your questions. The Court of Appeals, they identify, once broadly speaking, that there are professional services being rendered, then it's not for this particular statute. The legislature created this common law exception. They codified it. This is a co-equal branch of government, and common law, 9 opinions in the Court of Appeals and 8 opinions in the Court of Appeals and 1 here have found this is a broadly applied and not allowed UDTP claims to go forward. They all involve black hat activities. Not that I want to wear one, but in Gaunt we have criminal and defamatory activities. In Phillips we have a doctor lying about whether he's board certified, and I think I discussed Wheelis in detail. They said it was a criminal action with malicious purpose. In Abrams we had a contract. In Zaldivar we had a contract that was a non-compete. We had credentialing issues in Cameron. We had billing issues in the Shelton Duke Hospital case, and so. And we even have the Busby case, which is one of my personal favorites, where the physician, Dr. Busby, told all the other doctors in the community that the jury had found him guilty of malpractice, and the Court of Appeals said because he didn't want them to treat them. And those jurors were not allowed to sue the doctor when he's trying to say, hey, colleagues, don't give these people treatment. It's just such a broad exception that the case law really, and I think the state's brief really kind of does invite this court to overturn the, honestly, Sykes and the appellate court decisions and say this is a very narrow exception. It maybe only applies to malpractice. Yes, Your Honor.
Quick question for you. In your brief, you indicated that, and I'm reading from page 40, 41 of the brief.
My brief, Your Honor?
Plaintiff's new brief, that both parties to the litigation as medical professions are members of a learned profession. Does that mean that the hospital as a whole is a member of the learned profession, including everybody in there, regardless of whether they are individually members of the learned profession?
It makes you feel icky to say every single person in the hospital is a member of a learned profession. That's why there's that second part of the Sykes test.
But you don't get to that if you don't pass the first one, right?
Correct, Your Honor. But I think you can look at them together as an inquiry as to whether legislative exemption applies. Is there a learned profession? If, for example, it's not, you don't only have to go. But you could say, is it a learned profession, and are they doing professional
But
services?
is it the hospital that
Yes.
you're arguing is a member of the learned profession as a whole? The whole hospital, everybody there?
Yes, Your Honor, and I argue that because it's in the Wheelis case, the Shelton case, which specifically said hospitals are members of a learned profession. And I'm sorry, Your Honor.
Does that then mean that if anybody in the hospital, regardless of whether they are degreed as a learned professional, if they're engaged in something relating to medical services, is going to be exempt? Isn't that sort
If I could just have a few seconds to answer, Your Honor, please. But
Run.
I would like to answer your question. So we've said a hospital is a member of a learned profession. Then that's where the common sense comes in with that second part of the test is this rendering professional services, or is this someone, painting lines in a parking lot? And so, respectfully, Your Honor, I stand on my briefs to answer the rest of your questions, and I apologize. Thank you very much, Your Honors.
Thank you both. And thank you so much for traveling to Salisbury, Rowan County for this historic argument. Madam Clerk.
All rise. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 9:30 tomorrow morning in Asheboro, North Carolina. God save the state and this honorable court.